Who gets the house in a divorce? This is one of the biggest questions that we get. I'm John Henderson. This is HH Law. So who's going to walk away with the house in the midst of a divorce? That question comes to us in almost every instance where the husband and wife own a house together. And the answer to the question, not surprisingly, is it depends. And so it's all fact specific, who owned the house, when they owned the house, whether they bought it together. But we're going to go through each of these different scenarios and try to determine and help you understand who is going to walk away with the house. A house is often a couple's biggest asset. And so for that reason, everybody's going to be fighting to try to get that. Sometimes the house is a marital asset, and sometimes it's a non-marital asset. Marital assets are simply those assets that are divisible during a divorce. An inheritance, for instance, is that somebody inherits some money from grandparents and it's sitting in a bank account, never used as part of the marriage at all, would not be, in South Carolina, considered a marital asset. Something else, family property that's never used for the benefit of the marriage, would not be considered a marital asset. But a lot of times with a house, that is certainly a marital asset. And we'll talk about scenarios where it's not. But in your typical situation, husband and wife get married, they purchase a house together, they are paying the mortgage more or less together. Determining who is going to walk away with the house can be a bit of a tricky, messy situation. What we like to look at in family law is that the resolution of these things are usually like puzzle pieces, moving things around. You get these assets, this person gets these assets, various different puzzle pieces. Oh, the puzzle doesn't fit just right here, so we're going to have to throw everything out and try again to make sure that we get those puzzle pieces right. But in the instance of a no-fault divorce, where husband and wife are both on the deed, they purchase the house together, generally we are looking at a 50-50 split of the equity. So we're talking about the equity in a home. For simple numbers, we're going to take the value of the home. Let's just say that it's $500,000. Subtract out everything that is the outstanding mortgage debt on that home. Let's just say that that's $300,000. That leaves $200,000 in equity. Part of that is appreciation. Part of that is what's been paid into the mortgage already. But yeah, that $200,000, and under a lot of circumstances, we would simply split that 100 and 100. But who is going to actually stay in the house? A lot of that is going to depend on who can buy the other person out. So let's say husband and wife under that circumstance, we've got husband is getting his 100 and wife is getting her 100, but she wants to stay in the house. She would have to find a way through refinancing or borrowing money in another way to give husband that $100,000 and tell him to scram and get out of there. The question, though, is what happens when both people want to stay in the house? A lot of times, you're going to have to end up selling the house and then just splitting those proceeds 50-50 between husband and wife. If both won't budge, if both are, hey, I want the house, she can't have it, he can't have it, that circumstance. So either husband can have it and buy the wife out, wife can have it, buy husband out, or you end up selling it if nobody can agree on who should have the house. Now, what complicates this is that there are a lot of people in recent years that have like 3% mortgages, and mortgage rates, as everyone knows, is really skyrocketed. So the scenario where somebody might have to refinance to buy out the other party can really throw a wrench in all of these plans and make it very complicated. The other scenario there where you're still thinking about husband and wife who purchased the house together is, what do we do with the children? And so typically in a family law case, the parent who is going to maintain primary custody over the children is probably going to stay in the house on a temporary basis. Okay, so right out of the gate, we file the lawsuit for divorce. A judge determines, let's just say a month later, we have a temporary hearing and determines that mom should be the primary custodial parent and that dad is the one who's going to be getting visitation and paying some child support. In that circumstance, mom's going to stay in the house, and now she's in a really strong a place to say, look, I want to keep the house, and she's going to have to figure out how to buy dad out in the final divorce settlement. So not to confuse the two, but there's going to be a temporary agreement that is going to address the custody issues, but also the house issues. Who's paying the bills? Who's paying the mortgage? Who's paying the light bill, water, all the rest of it? Maintenance. Who's responsible for maintenance? How we're going to divide that up. That's all going to be handled in a temporary fashion. And that's what we're going to be living by until we get a permanent settlement agreement. And that's what's going to be negotiated about, like puzzle pieces moving around. Now, let's take another scenario here where one of the husband or the wife purchased the home prior to the marriage. And people call us all the time asking the question like, well, her name is not on the deed. I get to keep my house, right? And my answer to that is always, it depends. So let's take two scenarios in that circumstance. Husband purchases the house 6 months before he gets married, and now they're married for 30 years. That's hardly saying that he owns the house and she doesn't. So the fact that he's the only one on the deed is a little bit more of a technical issue than it is a realistic issue. Yes, he is on the deed, but she has been contributing for 30 years. Both parties are contributing to that mortgage, living there. That's her home as well. All of that equity build over that 30 years is likely to be a marital asset to be divisible. Now let's take another scenario there where wife purchases a house. Her parents helped her buy it for cash several years before she ever gets married. Now she gets married, husband moves in, they're living there for 5 years or so. Most likely, wife is going to keep the house in that circumstance. There's been no real contribution from the husband. There could be a little bit of equity that you have to buy husband out. A little bit of equity if there's been some market appreciation or there were marital funds that were used to do some upgrades to the house. There are different scenarios there, but typically it becomes a little bit trickier. It's not just straight 50-50 split if one person bought the house. So those circumstances are going to depend. You're going to need to talk to a lawyer and really crunch the numbers on this to try to figure out whether or not the spouse that is not on the deed is somebody who should be getting any equity in the house at all in the instance of a divorce. Now, what also plays into who gets the house or a divorce is like, who was at fault? Okay, so a lot of circumstances are no-fault divorces. And so really you're looking at whatever equity we decide that is in the house is going to be split roughly 50-50 in some way, okay? But in the instance of somebody who has committed adultery, habitual drunkenness, that has been physically abusive, now we're looking at not a 50-50 split of those assets, but it could be something different, 60-40, 70-30, depending on the circumstances. And then also wrinkle into that, let's say that we have a husband who is the one that is at fault for the breakup of the marriage and wife is not, and they have 2, 3, 4, however many children. Wife probably stands in a good place to stay in the house and also retain most of the equity in the house under that circumstance. Determining exactly how much equity she has depends on a ton of different factors, including the actual value of the house and the value of some of the other assets and how bad her grievances are against husband and whether she can actually prove that he was at fault for the breakup of the marriage. But all that is to say is that whether or not this is a fault-based divorce or a no-fault divorce is a significant factor in determining who's going to stay in the house, who gets to keep the house, and what the equity apportionment will be. All right, these are some of the factors that go into who gets to keep the home. If you have any questions about who gets to keep the home, if you want to be able to keep your house in the instance of a divorce, be sure to call our office. We're happy to talk to you about that. If you don't live in the state of South Carolina, contact a lawyer in your state so that they can better advise exactly based on the facts involved in your particular situation. I'm John Henderson, and this is HH Law.